Hello, my name is Paul Schmeltzer, and I'm a cybersecurity and data privacy attorney with Clark Hill. I also counsel healthcare clients on telehealth. The week of September 16th through the 23rd is Telehealth Awareness Week, and I've prepared a brief video about some of the legal considerations for healthcare providers wishing to practice using telehealth. Telehealth, sometimes referred to as telemedicine, lets a healthcare provider treat patients without an in-person office visit. The COVID-19 pandemic accelerated the adoption and use of telehealth technology. Telehealth is conducted primarily online with internet access on the patient's computer, tablet, or smartphone. Telehealth is a safe and secure way of connecting patients with their healthcare provider online. Telehealth care affords patients the flexibility to talk to their healthcare provider live over the phone or via video chat, send and receive messages from healthcare providers using secure messaging, email, and secure file exchange, and for using remote monitoring so a healthcare provider can check on their patients at home. At the state level, telehealth policies create a patchwork of laws governing virtual care. In many states, telehealth policies were tied to the state's public health emergency declarations that have now expired. To date, there is no federal legislation addressing telehealth policy. And just like in-person care, telehealth appointments, messages, and information are protected by privacy rules. Several states require telehealth providers to obtain written or verbal consent from the patient prior to delivering the telehealth service. Informed consent for telehealth typically involves a discussion about the telehealth technology and an overview of privacy and security considerations. Broadband and internet connectivity issues can deter patients, especially those living in rural areas, from accessing video-based care. However, audio-only telehealth is still a viable option for that population. The prescribing of controlled substances by telehealth providers remains in flux. At the federal level, the Drug Enforcement Administration has jurisdiction over these prescribing rules. The agency recently proposed regulations limiting the virtual prescribing of certain controlled substances without an in-person evaluation. But these proposed rules do not extend to Schedule 3 through 5 non-narcotic controlled medications or a 30-day supply of the medication for treating opioid use disorder. Healthcare practices also need to consider how they will keep their patients' protected health information private and secure. Electronic health records are often targeted by malware and hackers. The U.S. Department of Health and Human Services, Office for Civil Rights, and the Federal Trade Commission are cautioning hospitals and telehealth providers about the privacy and security risks related to the use of online tracking technologies that may be integrated into their websites or mobile apps and may be disclosing patients' sensitive personal health data to third parties. Tracking technologies are used to collect and analyze information about how users interact with websites or mobile apps, and may continue to track users and gather information about them even after they navigate away from the original website to other websites. Telehealth services need to comply with the Health Insurance Portability and Accountability Act of 1996, also known as HIPAA, which mandates protection of personal health information. Providers also need to be aware of any state laws that regulate the privacy and security of health information. In order to protect personal health information, telehealth programs need to assess how patients' data will be collected, transmitted, and stored, and identify any potential privacy concerns. Before deciding to offer patients telehealth, providers should check with their insurance company to make sure the insurance company covers telehealth. Otherwise, the provider may need to purchase supplemental coverage. If a provider plans to offer telehealth in more than one state, they will need to confirm that they possess the proper licensure and that their insurance policy covers all the states they intend to see patients in. Providers will also want to be aware of any state laws that regulate how they collect and store protected health information.